more broadly in the group litigation, could we please turn to poll 002764774? If we start on page 2, sorry, that's your E29. I won't read out this email because it's an email that we've seen, we dealt with it in depth with Mr. Parsons. He there sets out essentially why it was that an opinion on the merits in the litigation hadn't been provided or obtained originally, and it sets out there the strategy that had been adopted. What was your view on the strategy as set out here and the fact that there wasn't an overall opinion on the merits?
I do apologise. Which document is this one?
E29 of your bundle. It should end 6474.
Thank you.
Thank you. And it's page 2 is the email from Mr. Parsons. He sets out there that the strategy was to contest the common issues trial, and he sets out the thinning the herd strategy, and he says that the strategy was never to seek an outright win through the court process, because that would mean ultimately defending 500 plus individual claims. And he explains, I hope this helps explain why there hadn't been an overall opinion on the merits of the litigation in general. If it assists, if we turn over the page to the first page, you explain there, you say it does leave the Post Office in a difficult position. I remain surprised that no overall assessment on merit had been undertaken when there are 2 trials in. And then you also say that you should point out that Al, I think that's Al Cameron, was particularly disappointed on learning that the claimants had in fact provided a schedule of information in relation to quantum. And like him, you had heard numerous people advise that the claimants had not provided anything on quantum. Briefly, can you assist us with what your view was in respect of how the litigation had originally been approached?
So, as I think Andy's explaining there, I think Post Office took a very technical and legal approach to the matter. It was setting out to me what had previously occurred in the common issues judgment, which I understood took place in November of 2018.
And were you concerned by the fact that there wasn't, for example, an overall opinion on the merits of the litigation?
Yeah, I think at this point, because the strategy had changed, it changed even in respect of the common issues appeal, to narrow it down, to make sure the tone was right, to make sure that we were looking at mediation rather than a technical litigation defence. I think the strategy clearly had changed in June of 2019. I think what Andy's explaining there was a look back, if you like, at what the previous litigation was.
If we please turn to poll 002768883, that's your B68. Scroll down, please. It's on the same theme. It's an email from yourself raising concerns in relation to the lack of information regarding quantum that had been provided. It seems as though there was an email 1.5 years ago, but since, notwithstanding that email which had been forwarded to you, in the chain below, you say, even I have constantly heard since becoming involved that the claimants have not provided us anything on quantum, and it appears that in fact they had provided some figures. In what way did that, in your view, delay the settlement of the case, the lack of information that appeared in the business regarding the quantum of the claim?
I'm not sure it necessarily delayed settlement, in the sense that for me, and again, I'm sure others may have a different opinion, but from where I was standing, it seemed to me that the catalyst for change was the handing down of the common issues judgment and the failed recusal application. Because that was a shock, and that was really the crystallization of change. But what I'm saying in this particular email is that there are things that the way that the previous lawyers, Wombabon Dickinson in this case, had taken, although I didn't think that they were doing it intentionally. I think they were making generalized statements, and unfortunately, sometimes those generalized statements can be misinterpreted. And so I was just picking up the point that I had observed or been indeed told that the claimants hadn't particularized their claim, when in fact, what in reality was that they had provided some information about their claim, albeit it wasn't particularly particularized as it ought to be in a legal claim. So I guess what I was saying to Andy here is you need to be more precise with your language, because it could mislead. And I'm conscious, obviously, as the then General Counsel, I'm conscious to make sure that my lawyers don't leave a false impression or mislead the board, notwithstanding any, of course, no intention to do so.
Thank you. The final topic before we move to phase 7, and the final topic also before our next break, is records management. Could we please have a look at poll 004011613? That's your E58. You've previously given evidence in respect of disclosure to the inquiry, and this is a similar topic. This is a Risk and Compliance Committee meeting in which you were present on the 10th of September 2020, and it's page 2 of those minutes that I'd like to look at. If we scroll down, please, there's the section there on GLO/Freedom of Information Request/GDPR. It says the team remains stretched responding to historic shortfall scheme and related linked Freedom of Information requests. Following receipt of 41 Freedom of Information inquiries considered vexatious from one journalist, 31,000 boxes of data previously unknown have now been identified in storage. These are being reviewed by legal, Herbert Smith Freehills and Peters & Peters, and a separate paper for the Audit and Risk Committee will be prepared regarding the issue. The committee recognised the need for improved data retention management training across the group and in the retail network. Can you briefly assist us with the 31,000 boxes and how it is that they were identified?
So my understanding was that in the course of mapping out the relevant data repositories, that documents that I understand came from the retail part of the business was discovered, and it hadn't otherwise been indexed, or at least there was an issue around the indexing of the documents, and that it hadn't been captured in the previous reviews. And so I was extremely mindful of the fact that, and not just for this matter, sorry, and I mean the group litigation, but in respect of other legal matters as well, it was critically important that we have a data universe and that we understand what that data universe is, and that the business is complying with our document retention policy and the document preservation notices.
Thank you. Could we please turn to poll 000214662, and that's your E59. The issues then raised on the 22nd of September at the Audit and Risk Committee. If we scroll over to page 5 into page 6, please. The same topic. The team is extremely busy dealing with requests related to the historic shortfall scheme and related FOIA requests. If we could scroll down, please. It says, of serious concern and committee discussion was the discovery of 31,000 boxes previously unknown to the wider organisation, which are being reviewed. The committee questioned whether management had a handle on data management controls, such as archiving, and remarked on the lack of accountability within the Post Office. NR, I think that's Mr. Reid, remarked that this was an unacceptable incident and that he did not expect this to be brought to the committee's attention by compliance. A paper on data controls is expected at Group Executive for discussion. The committee recommended a data amnesty. There's one more document that I'd like to take you to, and that's POL 00167390. That's your E60. This is a board meeting, 22nd of September 2020. We see, if we scroll down there, there's the committee report from the Audit and Risk Committee. Carlos Dent provided a brief overview of the topics discussed at the ARC committee meeting held earlier in the day, including the pensions assurance update and the identification of 31,000 boxes. By this time, so we're September 2020, the Post Office have been involved in the group litigation since 2016. Did the Post Office have a sufficient grip on its own records, in your view, at this date?
No, it did not.
Who do you consider is responsible for that?
Well, data had sat with the CFOO. There had been a data director in the company who reported to Al Cameron. Data then transferred to the IT department. But to be fair, the accountability for data was something that was raised, or rather, the accountabilities generally, of which data was one, was raised as an area that needed resolution. I wasn't aware of the state of the organisation's data until this issue around the 31,000 boxes, and then subsequently all the remediation work that needed to be undertaken. But I had raised clarity around accountabilities at a broad level. And certainly when I became aware of Post Office's data and the state of its data, specifically the data universe, I repeatedly raised it to both the RCC, the ARC, and Nick Reid.
I don't think I need to take you to it, but there's an ARC meeting on the 12th of November 2020. That's POL 00423519. It's your E61, but I think we can deal with that without looking at the document. By that stage, sampling still hadn't taken place in respect of those boxes, so we're a couple of months later. Do you think sufficient priority was being given within the business to assessing that data, given that the appeals were at that point going to be heard in March 2021?
I think it's yes and no. So there were aspects where we were encouraging all the business to make sure that they have provided all data, to make sure that we understood what the data universe was. At this time, Mr. Salter had a head of data that was in his team. In the end, I actually shifted some of my resources, such as my compliance director and my operations director, to support the accountable business owners to map out the data universe to make sure, and I personally went down to the archiving unit, and I also went up to Chesterfield. I walked through every room to make sure, together with the third party. So I was particularly concerned from this point onwards about the state of the data and whether or not the organisation had got to grips on it. And I devoted more resource from my team to facilitate that.
And do you think the company is now properly on top of its records?
I think considerable effort has now been made. I obviously, as you will have seen undoubtedly in the ARC and RCC minutes, raised the legal risk around failure to have our historical data properly managed and the legal risks that creates. A substantial work and remediation program has taken place. There's now of a data director, which
Sorry, I think
previously there has been the establishment of a data council.
Sorry, I think you cut off briefly.
I apologise. So in short, a number of remediation steps have occurred with a data director, a data council, a lot more because of the frankly embarrassing and unacceptable issues around disclosure that the inquiry has obviously is well aware. The company is far more cognizant about its data management, and a lot more resource has been put in place.
Thank you very much. So we're going to move on to phase 7 issues. Perhaps that isn't a convenient moment to take a 10-minute break.
Yes, of course.
Thank you. Could we come back at 1:15?
Okay.
Thank you. Thank you, sir. Can you see and hear me?
Yes, thank you.
Could we please begin our Phase 7 examination by turning to poll 00289903. That's your E39 of your Phase 7 bundle.
Thank you, sir.
This is correspondence, if we scroll down, of the 7th of December 2019 with Mr. Watts. Was he a solicitor at Herbert Smith Freehill?
Mr. Watts is the partner.
Partner, thank you. You say he says in this email, again, we do not want to hear anything more from them other than an appropriate offer and settlement deed wording. We aren't going to have sessions with them in Chesterfield or wherever. Frankly, I don't think there's anything more to be said. As for Nick and I, we need to focus on the other 10,000 postmasters who are running the branch network. Sorry, this is from yourself. Other 10,000 postmasters who are running the branch network and serving customers over the busy December period. Hopefully, that gives you enough clarity to pass on to the other side. Is this a point in time where you're discussing settlement and providing instructions to Herbert Smith?
Correct. I think this was day 9 or day 10 of the mediation.
Thank you. The reference there to needing to focus on the other 10,000 postmasters, was it your view at this stage that the focus of the business needed to be reset onto existing postmasters rather than historic matters?
No, it wasn't as broad as that. What this email relates is that the original settlement and mediation had been set down for 2 days. I think the parties had an extensive negotiation and settlement. Post Office had provided a lot of additional information. Amanda Jones, the Postmaster Director at Post Office, had met with those in attendance at the mediation. Julie Thomas, the Operations Director, had met. They'd explained the improvements that they were making. Post Office also accepted to meet with the claimants for the following year to update them on progress. My concern at this point, and this is it's an email between lawyers in the matter, is that the mediation had gone a lot longer than it had been intended. And of course, although the group litigation is clearly one of my key matters, I am general counsel for all the other matters as well. And I guess this is some frustration that I'm expressing on Saturday about trying to balance all of that.
Could we turn to poll 00290399? Sorry, that's your E40. And if we have a look on page 2, it's a circular that was sent by Mr. Reid on the 11th of December within the organisation. And he says there, we are committed to a reset in our relationship with postmasters, placing them alongside our customers at the centre of the business. As we agree to close this difficult chapter, we look forward to continuing the hard work ahead of us in shaping a modern and dynamic post office. Mr. Reid's evidence to this inquiry was to the effect that you presented the issue of of prosecutions to him as a historic issue. Would you agree with that?
I did see Mr. Reid's evidence. I categorically deny that I told him not to dig into the past. I would not have said that. Indeed, I don't think any general counsel would. But I couldn't have said it because I'm clearly on record in the documents saying that even with the Horizon Issues trial being undertaken, once the judgment is handed down, the issue around criminal convictions would need to be looked into. And that's well documented that I said that in Steerco's and to the board, and I said that before Mr. Reid started, and I said it after Mr. Reid started. So for me to have said anything contrary to that is very odd.
You've said in your statement that there came a time at which you became more removed from the board. You've used words such as increasingly sidelined. When did that happen, and what happened to your relationship with Mr. Reid?
I was appointed as a temporary sponsor for the GLO and inquiry programs, but increasingly my direction and advice on matters were not being taken up, and I wasn't included in meetings that I asked to be included, such as meetings with Herbert Smith, such that it was making it increasingly difficult for me to maintain the veneer of the title of temporary sponsor. And I raised this in March of 2023 with Mr. Reid, again in April, and ultimately in July, I said to Mr. Reid that I would not continue to be the temporary sponsor of those programs in those circumstances.
And where does this all originate from, in your view?
I've made a number of recommendations and I raised a number of concerns to Mr. Reid and to obviously I raised them as well with the board, and I just wasn't getting the traction, and so I didn't feel it was appropriate for me to remain having that title when it didn't reflect the reality.
You've referred elsewhere in your statement to prioritisation of cost management over quality and speed. To what extent does that feed into that issue?
It is part of the issue, particularly when I did a review of the HMU and inquiry programs when Declan Salter, the previous director, left, and just prior to the appointment of the two new directors. And I made the observation that there was too much focus on cost management. I mean, even indeed when the two directors were in role, both of them expressed the concern that 40% of their time was to do with managing costs rather than the delivery of the program.
Putting compensation and redress to one side, because we'll address that as a separate topic, how has that focus on cost impacted on, for example, addressing the concerns raised by Lord Justice Fraser?
I would say that there is genuine desire by the business to get things done. I think the retail team, I haven't been able to watch all of the evidence with apologies, but you will have heard from Tracy Marshall and Mel Parks, I believe. And I think they have tried to progress matters as quickly as possible. My view is that they, like other parts of the organisation, have been stretched, and with constant restructures and constant cost reduction exercises, it has necessarily meant that reprioritisation has had to be undertaken in their areas, as indeed my own area.
Focusing now on compensation and redress, what was your formal role in relation to compensation and redress as at the beginning of 2020?
I was the General Counsel. At the beginning of 2020, we would have had the Horizon Issues judgment had landed. The settlement of the original 555 had occurred, and the establishment of what we called the post-GLE, the post-GLO program. And that program was chaired by Nick, and the purpose of that was to manage all of the implications that were arising from the Common Issues Judgment Appeal, i.e. the Post Office was not successful in terms of the Common Issues Judgment, and therefore to ensure that it incorporated all of the components of the Common Issues Judgment and that they were operationalised across the business. It included, similarly, the implications that arose from the Horizon Issues Judgment, and so that's where you will have seen that Peters and Peters and a series of counsel teams are appointed in respect of the criminal work. There was also a number of work streams, including the settlement conformance. So there were a number of obligations that were set out in the settlement agreement that Post Office needed to comply with. So it was a broad program of work.
I'd like to ask you about the overall business's attitude towards compensation and redress as at that period. If we could turn to poll 001555397. And that's your E10. It's an email that the inquiry has already been looking at. At the bottom of page 1, it's an email from Mark Underwood to Roderick Williams and yourself. If you scroll down, please. He emails saying, "Hi Rod, some comments for your consideration," and this is about setting up the historic shortfall scheme. And if we scroll down to the bottom, we can see the section on fees. And he says as follows: "My strong view is that you cannot seek payment from applicants, however small and regardless of the rationale behind it." Were you aware of consideration being given at that stage to charging fees to applicants?
I think there was reference made in a legal advice note. My understanding was it was in relation to the escalation process.
Can you assist us with what you mean by that?
So my understanding in that email, certainly, well, my view to Alan at the time was there should be no fees. My understanding was that there was, I think it was UKGI, who raised the issue generally around that in schemes you need to make sure that there's fraud controls within it. And then there was a subsequent dialogue and legal advice that Post Office obtained. And I think what Mr. Underwood is saying here is that he wouldn't have a application fee, but what he was suggesting is a nominal fee for the for claims that were not resolved by the independent claim, that it was for the if they wanted to pursue it to a mediation, which was part of the dispute resolution process.
He then continues, "Optically, this would be extremely challenging and would be a position that I believe the business would struggle to maintain under political and media pressure. I think you can achieve the same desired outcome, although having a very tight, that must be through having a very tight and clearly communicated set of eligibility criteria and requirements in terms of the documentation applicants have to provide in order to be accepted into the scheme." One reading of that is that a plan is being devised to make it more challenging for applicants to apply to the scheme. What's your view on that?
In reality, that isn't the case if you read the eligibility scheme. So the eligibility scheme for the HSS, firstly, the HSS, just for context was actually part of the settlement. It was suggested by the claimants that they thought that having such a scheme was important for other postmasters that weren't included in the original 555. They also made the point that it was important that such a scheme not require legal representation because the original 555 had to have legal representation because obviously it went through the court process. So with that in mind, Post Office established the scheme. The eligibility criteria for the scheme just required that you were in fact obviously a postmaster, that you say you have shortfalls, and that as per the Horizon Issues judgment, that your shortfalls arose under what was called HNGX or previous versions of Horizon, such as Legacy Online Horizon. So in those circumstances, there is not a hurdle or challenge to applying to the HSS.
There's been suggestion that the original forms were complicated. Who was responsible for that original documentation?
Herbert Smith Freehills drafted the original scheme documents. Obviously, Post Office is not a claims management company, and it sought advice from HSF as to the establishment of the scheme. I am mindful of also this inquiry's previous consideration in respect of the issue, and I accept, of course, I think with benefit of hindsight, being able to make things clearer, being able to put things in more plain English, I think are entirely fair observations.
If we scroll up, we can see that this email chain, it's sent to you, but also to Roderick Williams. Mr. Underwood says there, "Hi Rod and Ben, further to the below and purposely just to you, I'm not sure the workstream leads set out in Appendix 1 are set out in stone yet. For example, I'm not sure Nick wants me to lead the historical claims workstream owing to my prior involvement in the complaint and mediation scheme, chairman's inquiry and the GLO." Roderick Williams, that's obviously a name that we've been seeing from the very beginning of today, and it's somebody that the inquiry has already heard from. Had there been any prior discussion about people like Roderick Williams who have a history in the underlying matters being involved in any of those matters going forward, given their past role?
Yes, there had been. The challenge, and I particularly felt this quite acutely, which is this was a very complex, long-standing matter that had been running for years, and trying to get up to speed with everything, trying to understand where all the documents are, trying to get across the huge breadth of issues and detail was very difficult. And so on the one hand, it was important to be able to have corporate memory and be able to have people like Rod and others support us. Equally, there needed to be a counterbalance to that. And so I felt the fact that when obviously Rod was working in these matters, he was heavily overseen by external lawyers, and indeed the function of HSF was overseeing the litigation, that brought the counterbalance. Indeed, the external lawyers themselves actually advised that it would be very difficult for them to do their work if they didn't have access to those people.
Do you have a view as to whether the process that was set up was too confrontational?
I don't think it was intended to be confrontational. As I said before, it was a well-intentioned scheme in the sense that we were acting on feedback from the original GLO 555. We sought to make a scheme whereby they didn't need to have legal representation like the original 555 had. We were directly acting on that feedback. The scheme itself was one where we would have an external independent, I think it was 3 representatives that would assess the claims. It provided a dispute resolution procedure, and in fact the structure of it had been provided to the original 555 claimants, that there would be that escalation procedure. I think the fact that we understood that from an evidential standard that obviously it wouldn't be the same bar as one would employ in terms of litigation, and so I think it was well intentioned, but at the same time I do recognise, of course, that there are things that could have been done better.
Can I just ask, I'm obviously aware that there have been changes to the scheme, that's the HSS scheme, over time. Are all those changes the work either of Herbert Smith or some other outside firm of solicitors?
Yes, we've had a number of advisors, not just HSF, but there have been a number of Queen's Counsel that have also opined on matters.
Yeah, so the only point I'm seeking to make is that each change to the form or criteria or anything of that nature has been drafted by outside lawyers, not by Paul in-house.
Indeed. But I would add that those documents did go through governance. It did go through the board steering committees and UKGI and our government shareholder.
So the process is, if there's to be a change, outside lawyers draft it, and then it's approved by the appropriate people within the post office.
Correct. I would add that at this point, there were a number of in-house lawyers as well supporting the external lawyers to do so. But the work, I think, if I understand your question, the work itself was undertaken directly by the external lawyers.
Yeah, I'm not suggesting that there wouldn't have been conversations with internal lawyers, but the actual end result is the result of work by external lawyers and then approved by the board or whoever, to whomsoever the board has delegated that function.
Correct, sir.
Yeah, right.
There's been a suggestion in the inquiry that the view at the post office was that the schemes should be run by the Department for Business and Trade. Was that view ever expressed to you?
Yes. If I could perhaps, what was expressed to me wasn't necessarily that it would be BAYS or UKGI. I think initially what was discussed was whether or not it was appropriate for Post Office to run the schemes. My understanding is that Post Office raised that issue with UKGI and the government shareholder. There was a strong observation back to the board that the government shareholder would not allow, that the matter had to stay with Post Office, and that Post Office had to administer the scheme. Once that was understood, the board then made the decision that if that was the case, then it would separate the compensation matters into a separate business unit from what we call the BAU business.
In respect of Mr. Reid's views, were you aware of his views as to whether it was appropriate or not for the business to be running the scheme as opposed to government?
I think a number of representatives, including Mr. Reid, including Al Cameron, advised that they raised the question of, putting it in frank terms, whether the perpetrator, so to speak, should be administering the compensation. It was a point directly raised.
Raised with who?
the government shareholder and UKGI.
And is it your evidence that the government shareholder and UKGI were not open to that possibility?
Correct.
Thank you. So I'm going to move on from compensation unless you have any further questions.
No, thank you. No.
I'd like to deal briefly with the pineapple email, as we know it. That's POL 00448302. I'm not sure what your bundle reference is for that particular document, but I'm sure it's one that you will be well familiar with, as are we. If we scroll down further over the page, please. Scroll further. If you could keep on scrolling, please. Thank you. So this is the Project Pineapple note from Mr. Staunton to himself. It's the note of the conversation he had with the two sub-postmaster non-executive directors on the 10th of January, sorry, on the 14th of January, 2024. You'll be familiar with the paragraph that addresses yourself, if we scroll down. It says, equally, Saf and Elliott are fed up with the amount of power wielded by Foat. He and other members of the senior team act as if postmasters are guilty until proven innocent. As per my experience, they both said. Just pausing there, is that something that you have said? Or...
I have never said that people are guilty until proven innocent. I have maintained the view throughout my entire tenure at Post Office that we need to adhere to the Common Issues Judgment, the Horizon Issues Judgment, and Hamilton, that people are innocent until proven guilty. That is, one need not be a senior lawyer to know that point. And I am on record repeatedly saying due process needs to be done, but absolutely people are innocent until proven guilty.
And they continue, whilst Foat is at the helm, nothing will change. What do you think went wrong here with between yourself and the non-executive director sub-postmasters?
I think this came off the back of an issue with Mr. Staunton. After this email was given to me, I received an apology from the two postmaster Neds. They were in the apology to me, it was a meeting, they said that Henry had whipped up this issue. And I said to them, and I went through this email with them because I wanted to explain to them that the observations, allegations that were made in this email were false. So that, for instance, the power that I was wielding as a result of the inquiry could not be right, given that I stopped being the sponsor of the inquiry and I was conflicted and I did not attend the inquiry steercos from July 2023. So for half a year, I'd not been involved in the inquiry, and yet here is an email suggesting I'm, in capitals, wielding power as a result of my work in the inquiry. So I explained that to them. I also explained that the reference to Steve Bradshaw was incorrect because Steve Bradshaw and the investigators in that team have never reported to me. They are not part of the ACI team, which wasn't created until 2022. And so any conflation between what previous investigators may have done with my team was not right and was unfair. And the other issues around, I think there's a reference to me pushing Phoenix into the long grass. I told them that I would show them the emails that when I was involved in terms of the particular investigation, that I had in fact done the opposite, which was to ask my team to strategically prioritise it, to ask my team to progress it. Indeed, it was the then inquiry director who had overridden that direction. And so I went through this email with the postmaster, Neds, explaining why this was not a factually accurate observation, and which they apologised to me for it. And I have seen part of their evidence, and I noted that they did row back from, I think clearly in this email they mention Foat, and I think in their oral evidence they talk about legal rather than myself specifically.
Two follow-up questions from that. The first, Stephen Bradshaw and Project Phoenix. Why was it taking so much time?
So Project Phoenix was established as a result of the inquiry response tracker. This was an operational process that I put forward for the inquiry team to do so that we could track all issues that were coming from the inquiry. It actually wasn't just the inquiry, it was also as a result of FOIAs as well. And the business, the relevant accountable business owners could address it. Part of that response tracker included allegations that had been made by certain people. And at the time, I think the ACI team was relatively newly established. They had very little resource. We did communicate with the executive and board about the lack of resource, but I was very clear in 2023 to JB, Sarah and Diane Wills to say that Phoenix had to be strategically prioritised. And even in, I think, an email in March 2023, I directed the legal director, who oversees the ACI director, to even take other lawyers off if necessary to make sure that Phoenix was addressed and was given the priority that it ought to. To be fair to the team, I do want to say they did repeatedly raise the fact that they needed more resource and support to the finance team and to the executive, which I supported them in doing so.
And was there difficulty obtaining the funding for that?
Yes, they asked for it 3 times and it was denied twice. And then in the end, they did secure additional resource towards, I think it was August from memory.
Who, in your view, is responsible for the delay?
I think in part, I think it is multifaceted. I would have thought that had there been more resource, more funding, that would have enabled the ACI team to complete its part of the work. And then, of course, it's then handed over to HR, who then has the panel discussions, which were, I believe, set up in October of 23. I don't necessarily think it is one individual person. At the time, I think one has to also acknowledge that the HR department, Karen McEwen only started in October of 2023. And so I think it was difficult for the HR team as well prior to that time. So I don't think there's one individual, but I do think a significant part of the delay was the fact that the ACI team was a new team and had not been adequately resourced, despite the fact that they did ask for that.
We heard from Mr. Bartlett yesterday in respect of the resourcing. Why do you think it is that they are not sufficiently resourced in both yours and Mr. Bartlett's view?
I think at the time when, and this is like many things, including in other organisations, I think when you start a new function, and then you start to lift rocks, you start to try and make improvements, you try to remediate, examine the issue and address the issue. the workload increases. And I think in part, it wasn't fully understood just how many different types of investigations would be needed from the ACI team.
And why didn't those investigations, why wasn't the mechanism put in place far earlier? So I think you've mentioned that it was in response to the inquiry. Why wasn't it before then? Why were people still working in roles, and why was there no investigation into those people prior to it being raised as a matter relating to the inquiry?
I think, well, certainly in respect of my team, I had considered the issue. I had raised the issue with Nick Reed. We had looked at a number of people in roles, and this balance between corporate memory, but also making sure that there was the counterbalance of having external people. So I can't speak more broadly for the organisation, but I had worked on that issue in respect of my team.
Thank you. Before I pass over to core participant questions, do you have any reflections in respect of the role of General Counsel, the role that it plays within the business, how it might be improved?
Yeah, I think it's fair to say that being the General Counsel in this period of Post Office's history was and is a challenging role. One needs to be able to challenge board directors, executives, but also be able to coach your team, be able to liaise with other parts of the business. I think having a mindset of embrace lifelong learning, which is a value, personal value and a corporate value of a previous company that I worked at. Having that mindset, but also leading from the front in terms of making sure that people understand that legal conformance is a license to trade. It's not optionality, it's mandatory. And making sure that the business understands it at all levels, that complying with the law is essential to good business practice.
Thank you very much. We have some questions from core participants. We're going to take a break at 12:15, but perhaps we can deal with, Mr. Steen isn't currently in the room. Are there other questions, or is it just Mr. Steen? Yes, Mr. Henry and Mr. Maloney, perhaps we can hear from them first.
Yes, by all means.
Mr. Foat, can I understand your evidence about the compensation forms, in particular the HSS? You said that you didn't consider them to be, as it were, over-technical or unfair. Am I right in thinking that?
I'm not sure I did say that. I think I acknowledged that in hindsight they could have been clearer, and I'm obviously mindful of the issues that the inquiry has already identified, in particular around consequential loss.
Yes, and I'm going to deal with those in submissions because that is what the chairman invited me to do when I was putting that to Mr. Reed. But let me concentrate on the issue of contemporaneous documents. The guidance in the appendix, which was drafted, as you say, by Herbert Smith Freehills, uses the term contemporaneous 10 times. You acknowledge, don't you, that historically sub-postmasters were put in incredible difficulties by being deprived access to contemporaneous documents?
Yes, I understand that to be the case.
Yeah, I mean, because although this happened historically, it was referred to in the common issues judgment.
Sure.
And you remember that. That, of course, would have been 9 months old, the common issues judgment, when these forms were being discussed and when these forms were being drafted, wouldn't it?
I imagine so, yes.
And so therefore, at 3.2.2 of the form, it says greater weight will be attached to contemporaneous evidence, loss of earnings. This will require evidence, preferably contemporaneous, that the sub-postmaster was suspended. This is 5.22, or had their contract terminated without sufficient notice. Further references to contemporaneous correspondence being required in relation to loss of earnings. Further requirement for contemporaneous documents in respect of loss of profits, and it goes on. I don't think I need to go through all 10 instances, but you accept, don't you, that sub-postmasters were at a disadvantage in providing contemporaneous documents relating to matters which may have been by that time decades old?
Yes, I understand your point. I think it's helpful to note that in terms of the scheme, that the evidential bar was not going to be on a litigation standard, and that, of course, it is helpful if the postmasters do happen to have documents, but it's not saying that they that only references to be had to that. It's of course, if that documentation does exist and they have it, that it would be helpful to provide it.
So far as, and moving aside now from the historic shortfall scheme, but so far as compensation is concerned, it ought not to be an adversarial process. Do you agree? It was never designed to be an adversarial or litigation process, was it?
Yes, it's correct. It's different from litigation in a court. So, if I understand the purpose of your question, it is different from the court litigation process.
Yes. So therefore, I mean, in the case of Janet Skinner, for example, she has been asked to provide a 5th expert report. You obviously can't comment on the circumstances of her case, but that suggests, does it not, an exacting standard being advanced on behalf of the Post Office by its representatives?
I'm not aware of the specific details. I could suggest that having 5 expert reports. Oh, sorry, you are frozen on my screen.
Am I frozen?
Can you still hear me?
I can still hear you very well. Can you still hear me?
Yes, I can hear you. Yes, apologies. You are back now. Sorry.
Right.
So just in respect of, as a general observation, it would seem that 5 experts would seem a lot, but I don't know the particulars of the claim as to why that's being required. Obviously, I think Mr. Recalden is going to be before the inquiry on Monday, but I can take that away if you would like me to look into.
Thank you. Final thing. You accept, do you not, that in these negotiations over compensation, the Post Office must act with the utmost good faith and not indulge or transgress into any sharp practice. That goes without saying, does it not?
Correct, sir.
Thank you very much.
Thank you.
On the issue of compensation, you will probably have realized that in every progress update or in my interim report I have been careful to quote what both the government and Post Office had said on a number of occasions, namely, the aim is to provide compensation which is full and fair. All right, forget the prompt side of it for the moment. When I asked questions of both Mr. Staunton and I think Mr. Cameron in the recent phase, that is in phase 7, they appeared to be acknowledging that nonetheless there was a balance to be struck between the compensation payable to the postmaster and the fact that it was coming from public funds. In other words, public money had to be protected. As far as you are concerned, Mr. Foat, and I appreciate you may not be directly concerned in individual cases in the compensation schemes which the Post Office is administering, do you think that there is a balancing exercise taking place, or do you think that the panels or negotiators, or whatever the correct terminology may be, are seeking to fulfill the commitment to full and fair compensation?
Thank you. So I think I do understand your question. With respect to my colleagues, I think they are conflating two separate issues. One is to do with an overarching financial envelope that the government shareholder may have set aside, as distinct from the individual assessment of claims. The individual assessment of claims is done with reference to 3 external panel members, one being a QC, one being an accountant, one being a retailer representative. They are then assessed with respect to principles, and indeed at the requirement of government, we also needed to do test cases. And they are with reference to well-recognised established heads of loss. So, you know, that would include general damages, past and economic loss, special damages, etc. And so I don't see that managing public monies, although that is a separate legal obligation on Post Office generally, that does not pertain directly to the individual claims assessment in these cases.
Thank you.
Thank you, sir. If we could have questions from Mr. Maloney before we take a 10-minute break.
Certainly, yeah.
Thank you, sir. Mr. Foat, can I take you back to the start of your evidence this morning, or certainly the early part, when Mr. Blake was drawing your attention to the repeated messages sent by Mr. Williams and cascaded through the business about matters of privilege in respect to GLO, ultimately?
Sure.
Mr. Blake focused on the instruction that was given in relation to the creation of documents. And your evidence was that while you wouldn't have been supervising Mr. Williams in this work, you'd have seen this as relatively standard practice in civil commercial litigation.
Yes, I understand. So there is a standard process around what we call a document preservation notice. And so when, not just for this matter, but when there are any, which I think the legal test is anticipated legal proceedings, it is appropriate for a company or indeed a party to issue a document preservation notice as part of, I think later when I became legal director, I established a central repository of precedents. And I understand that the document preservation notice, although not necessarily RODS, but subsequently there is a, what one might say, a more enhanced document preservation notice.
Thank you, Mr. Foat. Can we just look very quickly again, please, at one of the documents that Mr. Blake showed you this morning, which is POL 20415-520. That's POL 20415-520.
With apology, what's the reference number?
It's E50 of your Phase 5/6 bundle.
I'm grateful to Mr. Blake, and I apologise to Mr. Foat.
No, that's all right. That's all right.
Thank you.
Yes, sir.
Thank you, Mr. Foat. The first page is simply an urging of all to read the email carefully. At page 2 of this document, we see the 3 crucial document rules, which are the standard practice, Mr. Foat. And you've been taken to those. I don't need to go into those in any detail. But if we go on, we see to the next page, we see what is a document and what are relevant documents. And we see the definition of a document, but number 1, but relevant documents are any documents that could either support or undermine the case of any party to the litigation. So the additional note includes advice on documents and duty to disclose documents which exist. You've told the inquiry this morning that as his supervisor, you said you knew that Mr. Williams was relying on Cartwright King when it came to any criminal matters.
That's what I understood. The resource was that he was relying on.
Yeah. There's no mention in this email of the post officer's continuing duties as a prosecutor.
That's correct.
Yeah. And would you have expected anyone to whom this email was being cascaded? And by that I mean people outside the legal teams to be able to understand any relationship between litigation privilege in civil claims and the ongoing duties of the organisation as a prosecutor from this email?
No, I think you're quite right, sir. I think this email was limited to a document preservation notice in reference to the High Court litigation, so the civil litigation rather than a criminal.
Entirely. Just in question about your experience, and perhaps quite complex experience here. This was a case involving civil litigation in a commercial context, brought in part by individuals who'd been prosecuted by the business. So a rare species of litigation. Had you, at that point in your career, had experience of commercial litigation against a prosecuting organisation?
No, sir.
And as his line manager, did you know whether Mr. Williams had had that unusual combination of experience either?
I was aware that he had been handling this matter for some years, so I was aware that he had experience. Just to clarify, he wasn't a criminal lawyer,
yeah.
But he had experience of both areas of law, if I could put it in those terms.
Yeah. Are you able to assist on whether at any time during your supervision of Mr. Williams and before the conclusion of the GLO, there was any message cascaded through the business clarifying that, privilege aside, Post Office may owe duties of disclosure to those who might have a basis for a criminal appeal?
Not off the top of my head, sir. No, I don't recall it. My vague recollection from 2019 was that there was a device that, and I think actually this was the same basis on which the CCRC proceeded, was that it was awaiting the outcome of the Horizon issues judgment.
Yeah.
I take your point is that there is an ongoing duty of care of disclosure. That is correct, sir.
Thank you. Just one final thing, please, Mr. Foat. In the autumn of 2020, lawyers were preparing for the criminal appeals hearings, which were to take place in February 2021.
Correct.
To your knowledge, was the fact of the discovery of 31,000 boxes of materials ever revealed to the Court of Appeal Criminal Division?
I think it was. It was flagged to HSF and Peters and Peters. There were what was called tranches of disclosure that was made, and so there were a number of QCs, and there were quite a number of junior barristers who were conducting the exercise, and it occurred over several months. Forgive me, I think it was around August, and I think the last disclosure was around February.
Yeah, and to your knowledge, did all of that disclosure in the criminal appeal proceedings, did that contain, did that follow examination of the 31,000 boxes?
I would have thought so, sir, given that St. Peters were directly briefed on the issue and were part of the resolution of that.
Thank you very much, Mr. Foat.
Thank you, Mr. Maloney.
Thank you. So could we take a 10-minute break?
Yeah, by all means.
Thank you very much. So 25 past, please. Thank you. to Mr. Foat. Mr. Steen.
Mr. Foat, good afternoon. Can you hear and see me?
Yes, I can, sir. Thank you.
Thank you. I'm not going to be very long. I've got two areas to ask you questions about. And can I take you, therefore, directly to a document that I think you will find in your Module 7 bundle at E3. And on the screen, please, FUJ 00243-199. That can be enlarged. Thank you. So, Mr. Foat, this is a letter written by Mr. Patterson of Fujitsu to Mr. Reed. The date you'll see on the face of the document is the 17th of May 2024. And I'm going to take you to one particular part of this letter, which is at the bottom half of that first page, please. And then under the second reference point there, which is pursuit of shortfalls from postmasters. And I'll just go through this. It seems that the Post Office may be continuing to pursue postmasters for shortfalls in their accounts using Horizon data. We would have expected that the Post Office has changed its behaviour in light of the criticisms and is appropriately circumspect with respect to any enforcement actions. And then Mr. Patterson goes on to say it should not be relying on Horizon data as a basis for such shortfall enforcement. Just as a reminder, Mr. Foat, Mr. Patterson is the European Director of Fujitsu, so a very, very senior figure within Fujitsu's operations. Now, my first question about this matter is that, bear in mind the date, 17th of May of this year, when was it first brought to your attention?
So I was on leave at the relevant time, so I wasn't involved in this matter. When I was due to give evidence previously, and I returned to the office, and the Interim General Counsel flagged to me this issue. I don't necessarily know if I've seen this letter, other than I have seen that it has been raised in other witnesses.
Right. So after the 17th of May, when you returned from that period of leave, this letter was brought to your attention, but you didn't see a hard copy or a digital copy of it. Is that what you're saying?
I don't recall. I recall the legal director, now General Counsel, flagging that there had been a issue between Post Office and Fujitsu, and that there was correspondence between the CEO. I don't know if I have all of the details of it, but I am aware of this letter, if that's the question.
When it was brought to your attention at that time, on the basis of there's been this issue between Fujitsu and Post Office, was it brought to your attention on the basis of, well, this is a bit awkward? Fujitsu are essentially not saying that you should rely upon the Horizon system to look at shortfalls. In other words, this is quite an important issue. Was it brought to your attention in that way?
Yes, it was raised with me that Post Office didn't accept for Fujitsu to be saying that their system, I think part of what Sarah had said was, obviously Post Office is paying for a system, and Post Office expects that it's fit for purpose. And so, but the conversation that I had with her is she was reassuring me that there was this issue. It's being looked into. The legal team, and I understood an external lawyer was involved in this correspondence. But I'm afraid I didn't have any other detail in respect of it.
Okay, understood, Mr. Foat. Let me just press you a little bit further.
Sure.
We heard yesterday from Mr. Bartlett. Mr. Bartlett being the Director of Assurance and Complex Investigations. That's John Bartlett. Now, his evidence included a reference to this particular document, and he explained that advice had been taken, it seemed to be from outside of the Post Office advice, which allowed the Post Office not to disclose it to police investigations. You were aware of that step being taken? In other words, advice being taken regarding this correspondence, leading to the outcome, which is non-disclosure?
I'm not aware of that.
given the background history of this scandal, which in really short terms is about non-disclosure, it's about not giving people the right information anywhere close to the right time, it does seem surprising that the Post Office still seems to be keeping back information that may be useful for the exercise of a police investigation. Do you not agree?
So I'm not aware of that advice. I haven't given that advice. I can't comment on that.
Well, I wasn't asking you about the details of that advice. I was telling you what Mr. Bartlett said in his evidence, Mr. Foat, which is the effect of his evidence is that they sought advice which led to this document not going out to police investigations. Don't you agree that seems surprising given the background to this matter and this scandal?
I would want to see the advice before I comment.
One of the concerns that might be said about what's going on here is this is very much same old, information that should go to the police so that they can investigate either in one direction against an individual or to consider whether their information is correct is being stopped at a bottleneck at the Post Office. Well, that sounds like history repeating itself, Mr. Foat. Do you agree?
No, that is absolutely not the ethos of the Post Office legal team or the ACI team. I don't believe that that's the case, but it's a bit difficult for me to comment on an advice I haven't seen.
Yes. In your current situation, are you able to look at such information and consider it, and then consider whether it should be reviewed by the team supporting the Post Office before this inquiry, and consider that for disclosure purposes?
Certainly, I can take that away and revert back.
My last question concerns something slightly different. Ms. Maloney asked you some questions just before the short break regarding the lead-up period to the appeals in the Court of Appeal Criminal Division. Now, at that time, in the lead-up to the appeals in the Court of Appeal Criminal Division, we know that Brian Altman, KC, was leading on behalf of the Post Office, responding to those appeals in the Court of Appeal, okay? We also know that Mr. Altman had a very long-term involvement in matters touching upon issues that relate to this inquiry, including at least being engaged on issues that relate to disclosure or indeed non-disclosure. And he's admitted that he's made a mistake in relation to dealing with matters of disclosure himself. Did he ever come to you, or to your knowledge, any other member of the legal team and say, I'm worried about whether I should be, in fact, presenting on behalf of the Post Office?
No, he did not, but it was the other way round.
I was going to ask the other way round. Thank you very much. What was the other way round, Mr. Foat?
Thank you, sir. So by that I mean it was Post Office that raised the fact of, obviously Brian had been involved. Mr. Altman is extremely experienced senior criminal lawyer, and frankly, he had a lot of information and memory on issues which someone like myself, or indeed a lot of other people, didn't have. So he was valuable from that perspective, but the board discussed the matter and the board determined that Zoe Johnson QC, another very capable, experienced Queen's Counsel, should be appointed as independent from Brian Altman. And in addition, the board also appointed David Calvert-Smith, who would oversee and specifically advise the board itself, separate from Brian Altman and Zoe Johnson QC. And so I think those measures or controls helped make sure that there was that counterbalance that I've referred to previously, that even if someone had been involved in the matter, that there was independent advice and expertise that sat independent from it, and indeed that there was also Sir David Calvert-Smith.
Right. to your knowledge, did Mr. Altman say or express his own concerns that I, Brian Altman, was part of the decision-making process and made an error in that process on disclosure issues, and express his, therefore, concerns about whether he had a conflict? Was that ever discussed with you? And in the reverse, was that ever discussed with him? Look, Mr. Altman, you're experienced, you're valuable to us because you've done a lot of work on this. Did the Post Office ever say you were part and parcel of that history of non-disclosure? Should you really be part of this? Was it ever raised in that term?
So the reverse, as said before,
Yes.
the reverse is the Post Office recognised that he had involvement. But just to be clear to your question, it was only until he gave evidence at the inquiry that I understand he acknowledged that issue. Before that time, Mr. Altman has never to me or anyone else that I'm aware, has acknowledged that point. If that's the question.
It's part of it, and thank you, Mr. Foat. I'll just check. No. Thank you, Mr. Foat.
Thank you, sir.
So we have one small matter from Mr. Maloney, then we have another small matter from Mr. Allen.
So yes, simply this, and I'm obliged to Mr. Foat, but Mr. Foat may remember that I asked him the question about the 31,000 boxes and the extent to which they had been reviewed and material from them disclosed for the purposes of the criminal appeal proceedings before the Court of Appeal Criminal Division. So we've managed to make some checks during the time that Mr. Foat gave his answer, and in fact those documents were reviewed prior to the substantive hearing of the criminal appeals.
Thank you, Mr. Maloney. Miss Allen.
Mr. Foat, my name is Christy Allen, and I ask questions on behalf of core participant Susan Sinclair, who was the first sub-postmaster to successfully appeal her conviction in Scotland. At paragraph 231 of your fourth witness statement, which I don't propose to turn up, you refer to steps taken by the Post Office between 2019 and 2020 in relation to individuals who may have been affected by bugs, errors and defects with Horizon, especially those convicted claimants and those who had suffered historic shortfalls. In that context, you describe liaising with external advisors and criminal law experts in terms of the post-conviction disclosure exercise and as a result of ongoing communication from the CCRC. Can you confirm any proactive steps that Post Office took, particularly in light of the Horizon Issues judgment in 2019, to immediately seek to rectify the miscarriages of justice which had occurred in Scotland as a result of its failing in its duty of disclosure?
Immediately after the Horizon Issues judgment was handed down, legal advice was immediately obtained and setting out the potential implications to criminal convictions. Subsequent to that, then Peters was appointed, and as we've just heard through the questionings with Mr. Stein, there were a number of other Queen's Counsel and judge appointed to that process. My understanding is that Peters also engaged with a Scottish criminal law firm, and I do apologise, I recall the name of that law firm, but those issues were then communicated back through Peters.
Perhaps I can maybe assist you with the name of that law firm. I think that might have been BTO Solicitors. Would that be correct?
Ring a bell. I don't know, but I understood that there was a Scottish law firm to advise under Scottish law.
Thank you. And did or has the Post Office engaged with the Scottish Criminal Cases Review Commission or Crown Office in Scotland directly to seek to rectify its failings from the past and to identify those affected sub-postmasters in Scotland?
My understanding is that there has been a liaison between the Scottish CCRC and with Peters and Peters. I'm not across the detail, but that is correct.
Okay, thank you.
Thank you, Ms. Allen.
So before we finish, I remembered that when I read out the witness statements at the very beginning, I read the first witness statement, second witness statement, third, fourth and sixth. I forgot the fifth witness statement, which is WITN 0998 0500, dated the 29th of May 2024. Mr. Foat, can you just confirm for us that your signature appears on that statement and that it is true to the best of your knowledge and belief?
It does appear on this statement, and it is in accordance with my belief. Thank you.
Thank you. Well, first of all, thank you very much, Mr. Foat, for providing all the witness statements to which you've attested. I'm grateful for you to that. I'm very sorry that in the summer, when you were ready to give evidence, that couldn't take place. I'm very grateful for you giving oral evidence this morning and agreeing with arrangements for starting early in order to facilitate what I have to do this afternoon. And finally, I'm grateful to you for your oral evidence today.
Thank you, sir.
I would like to say publicly that I'm grateful to everyone who has cooperated with making today happen, starting very early and the hearing running very smoothly. So thanks to you all. We now have, I think, a fortnight's break, and we resume on the 4th of November with Mr. Ricaldin, is it not, Mr. Blake?
That's correct, sir, yes.
All right, see you all then.
Thank you very much.
last night, see it? Crash. Yeah. 38-year-old woman, unborn baby, hit by a police car with sirens on. She died at the scene. Yeah, it's very sad. Yeah, the news in about 5 minutes. GB News. Hey, Sean, get my volume up a tiny bit, please, Ollie. Just a tiny bit.
On the side?
Yep, see. Sorry, I've lost the sound. I just heard a bit.
There was some music, yeah.
Yeah, that's weird. They're playing a promo. You got the same? Must be maybe it's stupid.
I can hear it.
No, you need it more than me.
No, I hear it.
You might need to phone, don't worry about it.
He knows. I've got to say one thing though about you people. The thing is great.
You see that man to my right.
You know that.
Top man, thank you. Might do that move to the right again. Right.
See Charlie and the boys. You know, they're in the racing channel in England. Yeah? Charlie. So I think they come there with a couple of hours to watch that. I did. Do you have the PA license in the city? Okay, so they've got the charge. Okay, yeah, all right. I'll let Charlie know. Thank you. They've got the PA license, so no need to say Charlie.
So they're not using me.
Oh no, the PA license, they use it for like
So I need to move around.
you don't have to move around.
So I'll be in boxes then.
No, so when you talk, instead of moving to the side,
They'll just like that.
it's right there.
You might have to intervene if he comes over and just leaves us slow.
Yeah.
Alright?
Yeah.
Good plan.
Probably that.
Here he comes now.
Just one sec.
maybe he's with Sky. They've got some great correspondence.
Probably his live stream YouTube channel.
Well, you'd be surprised. You've probably got like 5,000 likes. You'd be surprised. Yeah, me, honestly. Afternoon, Ben. Well, I've just spoken to a witness who saw the crash occurring yesterday evening, just after 6:15. We have now some more details about what's occurred. Previously, in the Metropolitan Police statement, it was unclear if that unmarked car was pursuing a criminal or attending to a scene. The footage I've now seen, there were sirens blazing on that vehicle. And now this witness told me that the car was travelling up to 90 miles per hour as it collided with the woman's car as she turned into the leisure centre just behind me in southeast London. At the junction between the Redwood Road and the A20. Now it said the woman was making the turning with her husband and another child, understood to be her daughter, waiting to be picked up at the leisure centre. That's what the witness said. He then saw the crash and ran out to try and support her. Now, the witness said that there were some 4 police cars, all Volvos, travelling with their sirens blazing down the road, also supported, he said, 3 to 4 motorbikes. From the footage that I've seen of the incident, in the moments after it happened, just the police car that hit the woman's car stayed behind, along with 2 other bikes to support the scene. But the other vehicles continued motoring away to attend whatever emergency they were called to. This witness described seeing the car, he said, flip up to 3 times before it landed about 10 metres further down the road. One wheel is missing. The woman and her unborn child, the police said, died here after that incident. There was a significant emergency response. In footage I've seen by another witness, there were around 9 ambulances here, also several trucks from the London Fire Brigade attending the scene. The Met said in a statement this morning that the London Air Ambulance also attended this location. Footage I've seen taken by a local resident shows that one of the vehicles, afterwards I understand it to be the police Volvo, had its roof removed. I understand signed also by the London Fire Brigade, a standard tactical procedure to access injured persons during a road traffic accident. Now, this witness, the 34-year-old delivery driver who saw the incident happen, told me that one of the police officers, a passenger, was hobbling to get out, but the driver was stuck inside the woman who was attended to up to 20 minutes later by an ambulance following that crash. As I said, he said it flipped some 3 times before landing on the side of the road. Some emotional tributes have been left behind, but the road is now clear.